Yes, sir.
May it please the court. My name is Brad Benny and I represent Mr. Johnson. There are two issues that are raised here on appeal. One is a Melendez-Diaz issue. The other one has to deal with what we would view as improper police testimony. I'll deal with that testimony first. What we're talking about here is at trial, the bulk buy defense. In other words, one of the defenses was that the cocaine that was on the defendant was his for use by him and was not going to be distributed. To dissuade the jury from accepting this defense, the police officer testified, and this is in volume 2, page 76 of the brief, that a crack user, based on his experience with crack users as a police officer, would not have that type of money needed to purchase the 98 grams of cocaine. A crack user needs to get high, so the time they have a 20, referring to money, $20 bill, they go out and they buy a 20 being some quantity of cocaine, to get high. So what this officer was telling this jury was that no crack user can ever have a large amount of cocaine on him, because anytime a crack user has some sort of money, he will then use it to go out, buy cocaine, and get high. The proposition is ludicrous on its face that's correct. It was not objected to at trial, and what we're talking about is a standard of a substantial risk of miscarriage of justice. One of the other things that aided the government in their dissuading the jury to accept this bulk buy defense.
But what's the legal proposition? That it's silly?
I'm sorry?
What's the legal proposition? That it's silly?
Well, no, that it creates a substantial risk of a miscarriage of justice because it informs the jury, based on the fact that they have a police officer in front of them testifying, that they would accept that fact, that no cocaine user could ever have a large amount of cocaine on them. And in fact, I've seen this in other transcripts whenever the bulk buy defense is raised. This isn't the first, and this isn't the last time you're going to see this.
So are you saying it goes beyond the scope of expert evidence, or it is an inference too far?
An inference too far. In other words, what it's doing is it's allowing the police officers to testify about characteristics of a drug distributor. In other words, that no drug distributor would ever have.
Drug user, you mean?
Drug user would ever have that type, and also allowing the jury to believe that because this defendant had a large amount of cocaine on him, he therefore must be.
What was he saying? Usually or always?
You know,
in the context.
In the context, it looks like he's saying always. This is a drug user would always have to go out and get high whenever he has a little bit of money on him. Whenever he has a 20, he would go out and buy a 20. Now, this is exacerbated based on the police testimony of the interaction with the bicyclist. As you recall, my client is in his vehicle. A person on a bike, they're apparently stopped. A person on a bike comes up, stops, and then they both go forward. The difficulty with this is the police testified that they didn't see any interaction or exchange. Now, I understand that, clandestine meetings or multiple people coming up to an individual with brief contact, the idea of handoffs, this all is evidence that shows that someone may be distributing drugs. But to tell the jury that, yes, a bicyclist came up, stopped right there at him. We didn't see an interaction. We didn't see an exchange. But this seems indicative of, once again, somebody who is distributing drugs. These facts taken together, the testimony, the evidence taken together, presents a substantial risk of a miscarriage of justice for this defendant because it does not allow the jury to accept or even contemplate a bulk buy defense. Now, again, the government is allowed to put in evidence like the fact that he didn't have accoutrements that a user would have. That's fine. They can put in what evidence they have. But in this case, the government is merely manufacturing evidence to preclude the jury from accepting the bulk buy defense. And that's the problem with this case. The appeals court below already said that this was error, but that it didn't rise to the level of a substantial risk based on the evidence in this case. And that based in light of the Melendez-Diaz issue. So if you have no further questions with respect to that, I'll just jump in.
I guess, is the issue foundation? I mean, is the issue that this police officer didn't have adequate foundation to describe the nature of what a crack user is? Or that no one can do that, that even a psychologist or psychiatrist who's conducted a study of crack use could not say what he said?
Yeah, I guess if the government wanted to put this type of information in, you'd have to have some sort of a Daubert-Lanigan test, a basis of scientific knowledge. But to just say that based on, and we don't even know how many drug users this police officer has come in contact with. But yeah, I mean, I guess basis of knowledge is correct. But the problem I guess I have here is that it's not most drug users I know. Whenever they have a 20, they go out and get a 20. It's all drug users. In other words, this was clearly meant to cut the bulk buy defense off immediately and to not allow the jury to even contemplate it based on this police officer's testimony. And
well, I take it the officer could maybe I'm asked, I shouldn't assume anything, that the officer could testify that the possession of quantities of this drug in these kinds of quantities is, in his or her experience, consistent with possession with intent to distribute.
Yes, and as I say in my brief, that would be absolutely permissible, and I think the case law on that is quite clear, and I'm not trying to argue that needs to be overturned.
Did the DA argue in final argument that you've heard from the police officer and all crack addicts always take their $20 as soon as they get it and buy their drugs?
No. But as the government always does in closing, they say, remember the evidence, and as the judge instructs the jury, your memory of what was said prevails. And in the court's or in the jury's memory, in this transcript was this language, and it's problematic because it's given to them from a police officer, somebody who's there in a law enforcement capacity. And I think case law says that even when you have a police officer up there testifying, you need to make sure that there is a special risk of a jury believing that type of testimony over others. And here that's the problem is the jury thinking, oh well, this is an experienced police officer. He's into law enforcement. He would, I guess, know that no crack user could resist saving his money to buy in bulk.
But the appeals court had a different concern, it appears. The appeals court wrote, the Commonwealth may not offer expert testimony regarding the expected characteristics of perpetrators of a crime.
And that's what it does, and that's what we argued below. And that's essentially what this does. That's kind of the middle step. In other words, the evidence allows that's essentially what the police officer is doing. He's testifying to these characteristics.
That's fact. Isn't that also the problem? He's saying them as fact?
Yes, he's saying them as fact.
Not opinion, but fact?
And as fact, yes, not opinion. As Justice Cordy said, had he, that suggestion is correct. Drug users or people who have this type of quantity on them, that's consistent with drug distribution, not drug use. That's perfectly permissible.
In my opinion.
In my opinion, yes. Now here, with respect to the Melendez-Diaz issue, and I can do this in 25 seconds, color does not get you anywhere near determining whether cocaine is cocaine, whether it has green, brown, red mold on it or not. Whether it's off-white or not, mere color cannot tell you whether a substance is cocaine.
Thank you.
Thank you. Your time is up.
Good afternoon, Your Honors. Diane Dillon, representing the Commonwealth in this matter. I think you have to take the testimony in context. The first officer, to testify, said that 4 or 3, perhaps, officers from the Narcotics Bureau were in the station. While they were there, they heard of a bolo for a certain car, and it was expected to have one driver and only one occupant. They all went out for coffee, and as they went out for coffee, they saw a car that matched that description. Dakin tells the other officer to turn around so that he can get the license plate number. He does turn around, they get the license plate number, and while he's running that, apparently somebody on a bike stopped, brief conversation, and went on. They got the information, and it turned out that the car was registered to Kevin Johnson, and he didn't have a license to drive. Based on that, they started to follow him. They followed him into a parking lot. When they got in the parking lot, Lieutenant Dakin saw the sole occupant, the defendant, throw something out the driver's side window. Stopped the car, let Officer Fopp get out. He went over, and 20 yards away, he found a bag of, it came out through him, through the analysis that went in, it was 98 grams of cocaine. It was a solid rock. That's what he found. Now, Lieutenant Dakin was asked, Officer Fopp, if he could testify about the process of getting crack cocaine from cocaine. He said, I'm not an expert. But he did note that what they found was much larger than the quantities they usually dealt with in the Narcotics Bureau. Then Lieutenant Dakin was put on as an expert. He went through how is it packaged for street sale, and he went through 20s, 50s, those are usually in baggies, the corner cut off, et cetera, and then there's the 8-ball, and that's usually in one chunk. It's larger and it's in one chunk. He was asked whether or not there were any implements for consumption. No, there were not. Did he appear high? No, he did not. Do you have an opinion as to whether or not the 98 grams of cocaine was more consistent with distribution or personal consumption? He said, based on the large weight and based on the cost, which he estimated to be $3,500 as it was, it would be worth $9,000 if it were cut back and sold as 20s. He believed that it was more consistent with distribution. Now, the comment he made about all crack dealers $20 is belied by his earlier testimony. It comes in 20s, it comes in 50s, and it comes in 8-balls. And I would suggest to you that it was inartful, but given what happened with the Melendez-Diaz issue, Lieutenant Dakin could certainly, if this court sends it back for retrial, be told not to be inartful at retrial. He's to stick to the facts before him and the opinions that he could draw. As far as the other elements the Commonwealth is required to prove, this was a conviction for between 28 and 100 grams of a Class B substance. When the cocaine was first brought into the police department, it was weighed. It was weighed in at 102. Came back from the lab at 98, and there was some testimony about it having been wet, or perhaps it was the plastic bag it was originally in. Nevertheless, 98 was the least we got from it, 102 grams when it was originally there. So the Commonwealth has certainly met its burden of proof as to the amount of cocaine. Melendez-Diaz presents a different issue. This case was tried in 2005. It happened in 2005, tried in 2006, and I think it was first briefed in 2008. I know I did a supplement after Melendez-Diaz was decided in 2009. And we have all been engaged in earnest discussions and deliberations about the scope and reach of Melendez-Diaz, whether it has to do with the defense, whether you can waive your confrontation right. And I think at this stage it's perfectly clear, especially from the 2 cases that this court decided in January of this year, that this has to be very strictly construed. That's the Commonwealth's burden once the certificate goes in, and it shouldn't have, because there was no analyst there. we have a strict burden of proving to you that the other evidence would nullify the intent of that. In this case, the officer was familiar with cocaine. He knew what it looked like. He knew how it was processed. He'd seen people ingesting it. He said twice he wasn't a chemist. When he was talking about the processing and the color it turned in the mold, the Commonwealth is not suggesting to you that that is sufficient. I think all in all, this case is very similar to Fluellen. And that was a case where the issue was whether or not he had it for consumption or if he intended to distribute some or all of it. And the facts of this case are very much on point. The Commonwealth did not present evidence to get us past the burden that we have to get past. So I would suggest to you that it's got to be remanded if you accept that concession for retrial, and at a retrial, the other issue that was raised will not recur.
All right, thank you very much.